G'day, I'm Stephen Page from Page Proven Family and Fertility Lawyers, and this is the Australian Family and Fertility Law podcast. So what I'm talking about today is the Australian Law Reform Commission Human Tissue Review. You may have heard about the Australian Law Reform Commission carrying out a review about surrogacy. Well, this is the 2-for-1 offer. Not only do we have the review currently being undertaken about surrogacy, but we also have the review about human tissue. They're side by side. This review was set up by the former Attorney General Mark Dreyfus just before the last election, and it's barrelling along. The ALRC has already issued an issues paper, which you can find online. Just go to alrc.gov.au and follow the links. Submissions are due by 4 July, so there's not much time in which to put in a submission. I must say, I had intended to put in a submission and I'll do so, but I've not yet drafted it, but I'll get it in on time. So what are the big things that concern IVF and surrogacy? There are 3 issues that stand out to me. The first is that there is a proposal to exclude eggs, sperm and embryos from the definition of human tissue and just plonk them instead under the Assisted Reproductive Technology Acts. Well, that might sound like a good idea at first because, well, we're dealing like for like, but that's going to have an impact on anyone who engages in posthumous reproduction, where there is a retrieval. Because what we've seen throughout Australia is that the ability to retrieve posthumously, particularly sperm, has had to rely in the main on the Human Tissue Acts. Now, these acts have 2 names, or 2 broad names to them. Human Tissue Acts, as we see in New South Wales and Victoria. Most other places, about half the places call them Human Tissue Act. About half the places call them Transplantation and Anatomy Act, for example, in South Australia and Queensland. And Western Australia had the compromise Human Tissue and Transplant Act, if I've got the name right. So excluding them will be a problem because there isn't legislation to authorise retrieval otherwise, except in Queensland. The second exclusion they're looking at is getting human milk out of the definition of human tissue. That would be wonderful. And we've seen that happen in Queensland. That happened back in 2021. At that time, the Health Minister said, look, we've got a bit of a problem. There is a view that human milk might be human tissue. Certainly the way I read the definition in Queensland was that human milk was tissue and that therefore impacts on human milk banks. It also impacts on those undertaking surrogacy, where there is a provision in the surrogacy arrangement or agreement for payment to the surrogate for provision of milk. So that can impact those undertaking surrogacy overseas. Not only might they get caught up by the relevant surrogacy legislation back here, but they might also get caught up by the Human Tissue Act. So I think it's a good thing that change happens. The next thing that looking at is who authorises posthumous donation, and that varies. And I have a series of videos, one I'm recording today and others I will be recording shortly, talking about posthumous retrieval in each state. So in general terms, and except in Queensland, who authorises where the body is in a hospital is the designated officer of the hospital. Experience has taught me that can be difficult in New South Wales. And if the body is not in the hospital, for example, it's in the morgue, it's a senior available next of kin. So there's some discussion about reforming that, and I think that's a good thing. And the last thing that is relevant is advertising and trade in tissue. because not only if you are engaging in egg, sperm or embryo donation do you run the gauntlet with the Human Cloning Acts. The formal name of the Commonwealth Act is the Prohibition of Human Cloning for Reproduction Act 2002, and there are similar laws in every state and the ACT. But you also run the gauntlet of the Human Tissue Acts, and there are issues about advertising for donors. For example, if you want an egg donor in New South Wales, there's no restrictions at all. You can put an ad up on Facebook or at your corner store. But in Victoria, there are significant restrictions in Queensland. To give another example, a clinic can't advertise without permission of the Director General, and if you're doing it in person, however, you can advertise. So a review of that area, I think, is warranted. If this interests you, certainly put in a submission. Thank you. You've been listening and watching to the Australian Family and Fertility Law podcast. I'm Stephen Page from Page Provan Family and Fertility Lawyers.